Good afternoon, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which is part of our Sophisticated Employer webinar series, sponsored by our Labor and Employment Law Practice Group. Regarding today's topic, I can say unequivocally that the internet is a wonderful tool. However, there are some serious potential downsides to its use, especially if you're a business owner or HR professional who uses it to access the social media accounts of employees or employment candidates. So that's why we're happy to have with us today two of our most experienced employment law attorneys, Rochelle Clark and Christina Coral, to hopefully convince you not to take the clickbait out there on social media. But before we get started, I always like to take just a couple of moments to provide some background about our speakers and our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have 7 Michigan offices, as well as offices in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's employment law practice group includes more than 20 attorneys who work in the areas of traditional labor law, human resources consulting, employment litigation, and even workers' compensation. Our Sophisticated Employer webinar series is designed to help human resource professionals, risk managers, and business executives stay up to date on important legal issues and to provide HR best practices while also discussing trends in workforce management. And now I'd like to take a moment to introduce you to our presenters today. As I mentioned, Rochelle Clark and Christina Coral are with us, and Rochelle is a member of our employment law practice group who defends the interests of public and private sector clients who are involved in a range of employment matters, including claims of sexual harassment, wrongful termination, and civil rights violations, amongst others. So Rochelle currently serves as co-leader of Plunkett Cooney's governmental law practice group, so we're glad to have her here with us today. Christina Coral is the managing partner of our Columbus, Ohio office, and she serves as co-leader of the firm's labor and employment law practice group. She has extensive litigation and trial experience defending employment cases in state and federal court. She represents numerous employers, and she has the distinction of serving as special counsel to the Ohio Attorney General for employment matters involving several academic institutions, including the Ohio State University. So now just a couple of housekeeping notes and we'll get started. For our Q&A portion of today's program, we're going to use the questions window on your GoToWebinar navigation display. So if you could take a few minutes now just to locate that and get comfortable with adding questions, you can type them in anytime throughout the program, and at the end, we'll try to answer as many as possible. We always like to try to keep those questions somewhat general in nature. We don't want to get too specific about particular workplaces. And finally, I want to mention that today's session is being recorded, and the recording will be available on the event page of Plunkett Cooney's website, which is located at plunkettcooney.com. So feel free to share a link to that event page so colleagues and friends can access this information. Thanks again for attending today's webinar. Now let's get started. Christina, I believe you're up first, so please take it away.
Thank you, John. Good afternoon, everyone. And thank you for spending your lunch hour with us today. So we have a very interesting topic today, and that's the use of social media in connection with employment. And as John mentioned, we all know that social media has its place and is very effective and useful for companies in getting out messages and advertising, allowing folks to know what the company is about. But there are also lots and lots of pitfalls involved in using social media in the hiring process, in the firing process, and also when your employees or supervisors and employees become friends on social media websites. So we're going to cover a bunch of those topics today. The first thing I wanted to look at is, and these numbers are updated all the time, the current statistics about employer use of social media. When I do this seminar in person, I always ask the attendees, who are mainly, employers and human resources professionals, to raise their hands if anyone has ever checked out an employment candidate or a current employee on the internet. And I get some red-faced expressions, but many folks in the audience raise their hands. And this, kind of these statistics back up what we all know, which is there is so much information out there for employers and others to gather on not only employment candidates, but on current employees, that is nearly impossible to resist the urge to at least check someone out on Google every now and then, and that's what this shows. So 12% of employers monitor the internet, including employee blogs. 70% of employers use social networking sites to research job candidates, and 39% of employers have looked up profiles of current employees on social networking websites. Now, I think these numbers are probably low based upon my interactions with folks that I represent. So, keep this in mind that these numbers are probably low. So what are we going to cover and talk about today? We're going to talk about off-duty conduct, social networking sites, and the availability of information on the internet. And this is the context in which we are going to discuss these issues: injury leaves, sick leaves, and workers' compensation claims, hiring, firing, and disciplinary issues, and the new frontier, which is sexual harassment and related issues. And that's a very interesting area because we are seeing more and more of this. And we'll talk more about it later, but let me explain what I'm talking about. I refer to this as the happy hour curse. So your employees go out to happy hour, whether it's a firm-sponsored event or whether they're just getting together after work, and everybody has a few drinks, and then everyone goes home and starts chatting with each other, either texting or because they've friended one another on social media, and now their inhibitions have loosened up, and then we have a problem. So that's really one of the new areas that we're seeing with regard to social media, is this sexual harassment type claim, and we'll talk about those specific cases that we have in our materials later. So let's start with leaves and work-related injuries. So let me set the battlefield for everyone. The battlefield for these types of claims is the private portion of employees or other persons' social media sites. So courts have been pretty uniform in holding that if you put information on the social media site that can be accessed by the public, you have no expectation of privacy, and that information is fair game to people, even including your employer. And I describe these situations as, I had a case not long ago where an employee called in sick for the day and then posted pictures of himself on his social media pages, whitewater rafting. So, those were publicly available, and the employer used that publicly available information to terminate the employee for, taking a false sick day. But the real battleground when it comes to the cases is the private portions of the social networking pages. So let's go to the first case. The first case is Ledbetter versus Walmart. This is one of the early cases in the area, and let me tell you what happened in that case. So there was a workplace injury. The employee was out on workers' compensation leave, and what happened is there were snippets of information publicly available on this employee's social networking site that seemed to indicate that maybe she wasn't quite as injured as she claimed to be in her workman's compensation claim. So when in the course of the workman's compensation case and then later in the federal court case, the employer said, hey, you've got this information that's publicly available. We want to see what information you have privately on your website. And so that's exactly what the judge allowed. The judge allowed that the information on the private portions, and I think it was Facebook, on the private portions of the Facebook page had to be provided to the employer so the employer could challenge this workplace injury claim. The next case, Romano versus Steele case. It's a 2010 case out of New York. Same thing. It was, this person who claimed to have been injured on the job published pictures on the public portion of her Facebook page that seemed to show her, out enjoying life, going on vacation. The employer found this information and said, hey, wait a second, we want to see the rest of the things that are on her Facebook page. And sure enough, the judge ordered just that. Based upon what was publicly posted, the judge said the employer is entitled to see also the private portions of the Facebook postings. The next one is not an employment case, actually, and I include some of these cases just to kind of send the message about how far-reaching your interactions on social media could be. This is a bullying case from a private finishing school in Connecticut. And what happened was the plaintiff sued the school and alleged that the school had failed to intervene and prevent her from being continually bullied by another group of girls. Well, the school and their lawyers looked at the plaintiff, this young woman's Facebook page, and the public portions of that page seemed to indicate that she may have been engaging in bullying behavior as well. So they went to the court, and the court said, okay, well, based upon what's been publicly posted on the website, I'm going to allow you access to the private portions of the social media website to ascertain, to judge the strength or weakness of the female student's bullying claims. Two more. EEOC versus Simply Storage Management. This is the context of sexual harassment claims. Female employees were claiming ongoing emotional distress about these sexual harassment claims. So what happened was the court said in this case there were some public postings that seemed to indicate that there may be some private postings that were relevant. In many cases, this is what the court says, and think about this when when you're posting things, even if they're on the private portions of your website, think about this. Almost all of these cases, the courts order unfettered access to the private portions of these social media websites. In other words, you have to give the other side your password, and then the other side is going to log on to your social media page as you, and they are going to be able to see everything. In this Simply Storage Management case, the court was a little more circumspect. It ordered the viewing of only relevant portions. So the court actually viewed it itself in camera and then provided the employer with relevant information about the claims of emotional distress, depression, and anxiety. The employer's request for the entire site contents was denied. This is a fairly unusual case. And then the next one is an insurance case. I mean, who knew this? Social media discovery certainly applies everywhere. The next one is a case that it's an insurance case. The plaintiffs were parents of some young women who had eating disorders, and eating disorders caused by certain conditions were covered under the healthcare policy, but eating disorders that were caused by other conditions, such as depression or anxiety, were not covered health conditions under the policy. So in this case, the insurance company went to the judge and said, hey, look, you can go to the next slide too. The judge said, hey, look, this insurance company is entitled to try to figure out the basis of these young women's claims regarding their eating disorders. So the judge gave the insurance company access to the private writings and postings on the social media sites so that the insurance company could figure out whether these claims were covered or not. So we gave you a quite a broad range of cases where these types of things come up, but I will tell you that they are very, very relevant in cases related to employment. And I'll give all you parents out there one more little tidbit that you can use in your private lives, or you can at least try to use, and that is this. I represent well over a dozen colleges and universities in the Midwest, and I will tell you that just about all of them check out the Facebook pages of students who are applying for admission to the college or university. And it is a standard practice in the admissions office at many colleges and universities to monitor the postings, and this would be the public postings, obviously, of students who have petitioned to enroll in the college or university. So to the extent you can convince your teenagers to keep it clean on social media, that's a good thing to do because we know people are watching. So the next topic, so this is all, we've covered the cases that have to do with matters that are already in litigation and what can employers ask for and gain access to for purposes of defending the litigation. And the next topic we are going to go over to is hiring and interviews. So what can you as the employer get from social media in the context of hiring and interviews? And remember, go back to our first couple of slides about, how many employers actually look at social media pages or do a Google search on candidates for employment. And so let's remember, what does a fully populated Facebook profile page contain? Okay, it could contain all of this stuff, not only the information that's here, your education and employment history, your friends lists, photographs, videos. It could contain information about your religion, what church you attend, or if you don't attend church, your political views, who and what sides of candidates and issues are you supporting? So then the next question from that is, then what information can employers get from a Facebook profile, right, that they could not legally ask if you were sitting in the office for an interview? And so look at this. You as employers and human resources professionals know that this stuff on this slide is off limits. You can't ask people about their, age, political views, religious views, marital status, union or political activity, medical information. Think about all of the medical information that's available on a Facebook page. Someone is diagnosed with something, and the next thing you know, it's on the internet, and everyone is posting well wishes, and this is information that your employer could not legally ask, but who an employee or a candidate for employment is voluntarily posting on the internet. So the caution to employers is, I remember, say 10 years ago, it was in vogue on employment applications to ask candidates for employment to provide their social networking usernames and passwords, so the employer could get on the website and check. And I'll tell you, this was very prominent with law enforcement agencies and other governmental entities because there's a lot of background checking that goes on, for instance, with FBI agents, with police officers, with firefighters, with social workers. So it really was a fairly standard practice some time ago. Now, this has been a while ago. And in response, many states have passed, 20 states, including Michigan, in fact, have passed laws that forbid employers or potential employers from asking employees or applicants to grant access or to allow observation of or disclose information on personal internet accounts. So So that's, and we can jump ahead a couple slides here. Again, it's not per se illegal to get on and look at candidates or employees' public Facebook pages. It's not per se illegal. The problem is what you do with that information. So if you as the employer are conducting an investigation regarding either a candidate or a current employee, you can conduct an investigation to ensure compliance with laws, regulations, workplace misconduct rules, your employee potentially stealing from you, those types of things. But you can't use, information that could potentially be discriminatory that you find on someone's Facebook page. I had a case, it was not that long ago, and I hate to even bring it up, but it's worth saying because this stuff still goes on. I had a case that I was representing an employer, and someone interviewed for a job position, and the employer did some research, not at my direction clearly, did some research on that employee's social media account and found out that that employee was a religion, participated in a religion with which this employer did not agree. And so I got a call from the employer asking, I haven't hired them yet. I found out their ex-religion. Do I have to hire? I would have hired them if I hadn't figured out that they belong to this religion. But now that I know, can I just choose not to hire them? And I had to tell the employer it's illegal to make hiring decisions based upon religion. But at that point, the cat's out of the bag. And so employers have to be very, very careful because anti-discrimination laws still apply, no matter whether you got the information from another employee, from somebody's Facebook page, from their employment application. It doesn't matter. Anti-discrimination laws still apply. And third-party background checks, as we all know, if you're doing a third-party background check that includes social media sites, you still have to follow the dictates of the Fair Credit Reporting Act. So always keep that in mind when you're looking at folks that are applying to your firm or company for jobs. So now we are going to move on to the next topic, which is terminations and discipline and the role that social media plays in terminations and discipline. And for this portion of the presentation, we're going to turn this over to my partner, Rochelle Clark.
Thanks, Christina. So earlier in the conversation, Christina mentioned how social networks have essentially blurred the boundaries between employees' personal and professional lives. And as you see, there are a lot of employees who are friending each other on social media platforms and following one another. And so employees are easily getting access to information about what other employees are doing in their free time, in their personal lives, what their personal viewpoints are. And this in turn leads to the employer obtaining this information as well, even if it's not intentional. So the question becomes, what do you do when you become aware of a problematic posting? And can and should you, as the employer, fire the employee? Now, we're going to look at a few cases here in which most of the terminations were upheld. So the first case is the Sumo case out of the Court of Appeals of Texas. And in that case, the plaintiff was an EMT. And so one of his coworkers posted on Facebook, and he was frustrated about dealing with a patient population that's aggressive and suggested the use of restraints. The plaintiff had the bright idea of getting on and commenting on that post and made a comment to the extent of using a boot to a patient's head as a form of a restraint, and also made a comment about that was pretty insulting to the police department, and implying that they weren't offering the help that they needed to with this patient population. And of course, a third party saw the post on Facebook, contacted the CEO of the company, and was pretty outraged by the comments that these EMTs were making. The company did an investigation, and then they terminated the plaintiff shortly thereafter. The plaintiff filed suit and claimed that he was unlawfully terminated, and the court essentially decided that the employer's argument that they had a policy in place that prohibited employees from speaking or using indecent language or profanity or abusive language when talking about patients, that policy applied to this comment that this individual made on social media. And so it was perfectly appropriate that he was terminated for violating this policy. And the next case is kind of similar in terms of you see the court allowing the employer to terminate an employee once there is a policy in place that has been violated. The Rodriguez case is out of the Fifth Circuit, and in that case, the plaintiff was a cashier, and she was friends with some of her coworkers on Facebook, and she happened to be on Facebook and saw two coworkers at a 4th of July party. No harm, no foul, right? Well, wrong. She noticed that some of the people in that photo had called off sick that day. And so this enraged her, and so she got onto Facebook and commented on the photo and essentially called them out for lying and not being truthful and, calling out of work when they clearly weren't sick. So her coworker, well, let me backtrack. So she came to her senses shortly after and deleted the post the same day. But as we all know, once you post something to social media, it's there. You can delete it, but within the moment that you post it, someone can take a screenshot of it or a picture of it, and then it exists forever. So in any event, the coworker reports her to the company, and an investigation is completed. And once again, the company looks to its social media policy, which spells out clear as day that employees are not to confront one another on social media about work-related issues. And so they determined that she violated this policy and terminated her employment. And the court agreed that her termination was based on legitimate, non-discriminatory reasons, and so the termination was upheld. So the next case is a little different because we're dealing with a public employee. And in this case, the plaintiff was a public school teacher. And so she posted two statements on Facebook alluding to the fact that she felt more like, quote, a warden for future criminals than a teacher. And then her second post was that she was inquiring about whether there was a Scared Straight program for first grade students. Now, she was a first grade teacher to students who were primarily Hispanic and African American. So as you can imagine, the students' parents were very outraged by this. And when they learned of these posts, they brought them to the attention of the principal of the school, and an investigation was conducted and the teacher was removed. She argued once she was removed, she took the position that her speech was protected under the First Amendment, but the court rejected that proposition and essentially said that she wasn't speaking on a matter of public concern. She was just speaking as a disgruntled, dissatisfied employee, and so the First Amendment protections weren't invoked. All right, so moving on to the next case. In the Carter case, we had a flight attendant who was Christian, and she learned that members of her union, members of her union had participated in a Women's Day march that was sponsored by Planned Parenthood. And she was very upset by this, and she expressed her dissatisfaction in this on social media. She commented on the union president's page. She commented on the union's public page. A series of comments that were very, 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 explicit. And her employer got wind of these posts and terminated her, although she'd had in her 20-year history of working at the company, she hadn't had a single disciplinary issue, but they felt as though this was egregious enough to warrant termination. So we fast forward a little bit, and she files suit, and she claims that the employer has violated her First Amendment right and also discriminated against her because of her religion. And so her employer moves off the bat to try to dismiss the claims, and the court agrees that the First Amendment claim, there's no basis for it because First Amendment claims apply to state actors. And so this individual's employer was not a state actor, it was a private company. I believe it was Southwest Airlines. So she couldn't sustain a First Amendment claim against them. But the court did allow her to proceed forward on the religious discrimination claim. So I guess that case is a bit of a caution that when you may have a policy in place and you may terminate an individual, but you also want to take into consideration any state or federal rights that might be invoked by that termination. All right, and so in the Monroe case, we see another public employee, and whenever you see these public employees, one of the first things and the main issue is always whether or not the termination impedes upon their First Amendment rights. So in this case, we're dealing with a public employee who's terminated after he posted some disparaging comments about his employer, and he filed suit and claimed that he was terminated because he exercised his free speech rights as a private citizen. The court once again basically said that he wasn't speaking about a matter of public concern, and they looked at the fact that he posted his comments on a friend's page as opposed to a public page. And so for those of you who are not familiar with Facebook, you can have your private page and have certain privacy settings so that only your friends see the comments or a particular group of individuals, versus a public page where anyone can access all of the information on the page. So the court said, one, he posted his comments on the friends page versus a public page. So it doesn't seem as though he's trying to speak on a matter of public concern. He's just speaking as a disgruntled employee who's dissatisfied with his employment. And I think this kind of, again, hammers in the point that just because just because you're a public employee doesn't mean that all of your speech is protected under the First Amendment right. So that's important to keep in mind as well. And so the next case deals with threatening posts, and that's a common case out of Pennsylvania. It's a pretty recent case. The plaintiff in that case was fired after her employer learned that she posted a really threatening statement about her manager on a Facebook page, and the employer subsequently took the position that she wasn't entitled to receive any unemployment benefits. The court upheld her termination and basically said that because her comments were threatening and qualified as willful misconduct, the termination was appropriate even though the quote-unquote misconduct didn't occur on the physical premises. So if there's an employee who is taking to social media and making threatening comments, there's certainly right by the employer to follow up and investigate that issue to determine whether or not it's something that needs action, because you clearly don't want to wait until it's at your door, so to speak. All right, and I think the last case here is the O'Daniel case, another case out of the Fifth Circuit. So in that case, a human resources manager actually took to Facebook and made some comments about a man who she had observed dressed in female clothing, and she made some pretty derogatory statements about that individual, and was very critical of that person. And her employer learned of this and took action and terminated her employment. And the court, again, sided with the employer and said that an employer can dismiss an employee at any time for any reason as long as it's not for a reason that's prohibited under the federal and state laws. So I think those cases are very instructive in terms of the different fact patterns that we see, and also how important it is to have a policy in place that addresses social media use, but also taking into consideration that there are potential First Amendment rights that can be implicated when you're dealing with public employers and employees. Christina is going to cover a couple more cases here for us.
Hello again. So I want to just say one thing about, go back to a couple of things that Rochelle, and that is the most common fact pattern that we as employers find when social media becomes relevant to whatever's happening with employment. And that is, in every case that I have ever been involved in that had social media as an element, we learned of social media issues not because the employer was monitoring or looking at social media sites of its employees, but because other employees brought it to our attention. And Rochelle outlined a couple of cases where that's exactly what happened. And so what we see is it's probably not necessary for employers to be looking at what their employees are doing on social media sites, because another employee is going to ultimately bring it to your attention. I've even had cases where family members of employees have seen something on social media that they found horribly offensive and brought it to the attention of the employer. So again, you know, these are all interesting issues, and the issues that you have could potentially be dependent upon whether you're a public employer that has to observe certain constitutional rights of your employees, or a private employer who does not have the same constitutional restraints such as freedom of speech, freedom of association, freedom of political belief that public employers have. So those, you know, we always need to look at what type of employer are we dealing with. So I'm going on to, in the next slide, there are lots and lots and lots of cases out there. They're very interesting. You know, social networking site information that was used to terminate employees, and this is almost all off-duty conduct, right? So employees are going home at the end of the day, they're making offensive posts. I will tell you that just within the last few weeks, because of, you know, the issues that are going on with the death of Mr. Floyd and the protests that are going on and the calls for change, I have gotten a heck of a lot of calls from employers who have received complaints about their employees posting racist comments, commenting about the death of George Floyd, and we've really had to deal with some very sticky issues regarding, you know, are we as an employer going to have a zero tolerance policy when it comes to race or offensive behavior on social media pages? So, you know, as Rochelle said, the basis of how you operate your business is going to come back to the policies that you've drafted and provided to your employees, and what you tell your employees about what is expected by their conduct. So I included this next case, this Petriol versus Hillstone Restaurant Group case, because this is an unusual case. So there was a group of employees who started their own sort of private internet chat. It was password protected. And they used that to say really terrible things about their managers. Now, putting aside the issue of whether, you know, discussing the terms and conditions of your employment is protected by the National Labor Relations Act, in this case, they were, you know, some pretty serious bad-mouthing of management and name-calling and that kind of thing. What happened was management got wind that this was going on, and it coerced one of the employees into giving the manager the password for the website. So the manager gets the password, he goes on the website, he sees all these comments, and the employees that had been involved in this chat were terminated. Now, in this case, the court reversed. The judge let the case go to the jury, and the court reversed the terminations of these employees based upon one fact: the fact that the employee that gave up the password was coerced, which means the inverse could be true as well. If an employee had voluntarily come forward and provided the password to this private chat room, it seems very, very unlikely that the employee's terminations would have been reversed. The next case, I have a series of cases for those of you who are public employers. So public employers are a little different, police officers, EMTs, firefighters, social workers, that kind of thing. Many public employers, for those type of employees, have what we refer to as conduct unbecoming policies. Conduct unbecoming policies say that you need to keep your reputation unsullied in the community, both on and off duty. So that kind of dovetails into a few of these cases that involve police officers and FBI agents and that kind of thing. So I don't know what it is with police officers and sex videos on the internet, but we have a whole bunch of them. So in this Palm Beach sheriff's case, there were sheriff's deputies and their wives made a sex video and they posted it on the internet. Even though there was no correlation between the video and the fact that these were sheriff's deputies, the court still upheld the termination. Same with the next case. A police officer in San Diego was videotaping himself masturbating in his police uniform. So he was then ultimately terminated. This case went all the way to the United States Supreme Court, and the Supreme Court found that that type of behavior was not protected by the First Amendment, so that termination was also upheld. The next one is John Doe versus Department of Justice. This is an FBI agent case. So the FBI agent was having sexual relations with some of his coworkers and was videotaping it. And he, somebody found out about it, and it was turned over to the employer, and the employer terminated him, and the agent was ultimately terminated, and the termination was upheld. Even though he argued that what he did off duty had nothing to do with what he did during his duty hours, the court agreed that that type of behavior, videotaping women without their consent, reflected negatively on the agency, and that's why that was upheld. So the law has been applied pretty broadly when it comes to public officials, public employees, police officers, firefighters. There's a pretty broad prohibition. There was a case in Missouri, and it's not that old, that a police officer videotaped himself coming home from duty that day, and he was taking off his uniform, and he was wearing Confederate flag boxer shorts under his uniform. As we all know, the Confederate flag most recently has been, seen as a symbol of racism, and so he posted himself on the internet in his Confederate flag underwear, and he was ultimately terminated from his employment, and that was upheld. So these are just things to think about if you're in the public employment game. The next issue, which, listen, we've seen a lot of this actually. So younger police officers, the Millennial Age grew up posting every single thing that they do on the internet and communicating with all their friends about every single thing that they do. It's just the way they were raised. So in 2010, and we've heard cases very similar in the United States, an Israeli soldier posted a status update on his page that contained the date, time, and location of a proposed raid that the police were doing in Israel. So the raid was canceled and the soldier was court-martialed. But I'll tell you this, we've seen it in the United States too. Police officers posting things about what they're going to be doing and where they're going to be going that are, a breach of security. and then ultimately lead to disciplinary action. So we are on to our last topic, which is hostile work environment claims. So I kind of laid the groundwork for this when we first started with our presentation. We really see these types of claims a lot where, and there aren't a lot of them, I shouldn't say a lot of them, but the cases in which we see them are cases where employees are friends on social media with one another outside of work. I just had a very long and difficult conversation just last week with a local police chief because the police chief, as a supervisor, had friended all of his officers on Facebook. So he was privy to everything that was going on in their personal lives and was frequently engaging in commentary and conversations about, what was going on in these officers' personal lives. And so when it came time that this police chief needed to discipline an officer, he was put in a very difficult position because he considered this officer to be a friend. They frequently communicated because they were friends on social media. They were sharing pictures of their families and acting as if they were related to one another. And then the chief was called on to discipline this employee with whom he had grown very close on social media. So I frequently advise employers that if you are in a supervisory or human resources position, it is not a good idea to be friends with people that you supervise on social media. It's just not. So I know it's hard for people fight me on it all the time and push back, but I continue my advice that you have to maintain a professional and slightly distanced relationship with people that you supervise. Not only does being friends with one another on social media, make you have more contact with each other outside of work. The problem with social media is it's a very casualized communication process. You communicate very differently if you're messaging someone on Facebook than if they're sitting in your office in the middle of a workday. And again, we go back to the happy hour conundrum. You're sitting at your computer screen at 8 o'clock at night, and you had a couple of glasses of wine with dinner, and you're feeling relaxed, and you start messaging with one of the employees that you supervise, and before you know it, you're going to say something stupid because you're relaxed because you've been drinking. It's a relaxed communication style, and people frequently get in a lot of trouble when they are friends with coworkers, supervisors, and supervisees outside of work. So that's my preaching for the day from my soapbox. That's my caution I tell everybody. Now, so far, courts have not recognized hostile work environment claims based upon claims of sexual harassment that came from social media. So far, I say so far because I'm sure it's going to happen one of these days, but so far this is what we've found. So the first case we have is, let's see. Oh, I think Rochelle actually found us a more updated case. The two that I had found, there's a Sumo versus Hofstra University case that the plaintiff was a student employee for the Hofstra football team, and the players made a series of posts and teammates made a series of posts about her and her boyfriend on their Facebook page. Because she was also an employee of Hofstra University, she filed a lawsuit alleging that she had been subjected to a hostile work environment. So the court looked at that case and said, this really isn't related to your work, and it didn't create a hostile work environment because you are posting about your personal life. You have friended these people, and these other people are commenting on your personal life. There was another case, is Amira Jabbar versus Travel Services case from 2010, that a female employee claimed she was retaliated against and subject to hostile work environment because she had posted, a coworker actually posted a picture of her a company golf outing, and they made some of her coworkers made derogatory comments about her. And the court found that because it was a single isolated incident, this one post, that it wasn't pervasive enough to give rise to a hostile work environment claim. So those are actually the cases that I had found. Rochelle, do you want to jump in and talk about this 2016 case that you located?
Yeah, so the LaPorta case is out of New York, and it's a 2016 case involving a female manager and a coworker. And so the coworker actually had a history of harassing other female coworkers, and management, at least this is what was alleged, management was aware of these prior allegations of harassment by this individual, but did nothing. So fast forward a little bit, and this same individual contacts the plaintiff via Facebook and makes a comment about her breasts. And the plaintiff immediately reports this to the CFO, her direct supervisor, and the CEO. And instead of following up on this, nothing is done. And she alleges that they isolate her. And she suffered from a medical condition. And again, this was part of her allegations. She claimed that all of the stress of the situation, as well as being isolated by her coworkers, caused her condition to flare up, and it was ultimately just too much, so she resigned. So she filed suit, and the defendant, her employer, filed an early motion seeking to dismiss her claim. The court said that based on the allegations, she had stated a viable claim for sex harassment, creating a hostile work environment under New York law. And so what that means is basically the court was permitting her to proceed with her claim, go through discovery, see if there was any evidence to support this claim, and substantiate the claim. So I think in that case, what is probably significant is that the individual who was accused of harassing the plaintiff had a history, at least that's what was alleged. And so it was coupled with also the Facebook comments made against the plaintiff, the history of sex abuse or sexual harassment by him to the other coworkers, and also the fact that after she reported it, nothing was done. So all of those allegations in their totality was enough for the court to say, okay, let the claim proceed and let's see what happens.
So yeah, and so that's a good place to leave off, Rochelle, because that brings us to our last message, which is we always get questions. Employee X is complaining that employee Y is harassing me on social media outside of work hours. Do I have to do anything about it? The answer to that question is yes. You as an employer, if you learn that one of your employees is being subjected to sexual harassment by another employee, you have the responsibility to take action to make sure that that behavior stops, even if it's Facebook and even if it's outside of work. So we get a lot of those questions. There are published cases for things like there was a famous case where a UPS driver who wasn't even an employee was coming in every day, dropping off UPS packages and sexually harassing the receptionist at this business. And the receptionist complained, and the business said, well, what do you want us to do about it? He's the UPS driver. He's not one of our employees. So they didn't do anything, and she sued, and the court said, oh, no. You as the employer have a responsibility to make sure that your employees are not being subject to a hostile work environment. It can be in the office by a client, for instance, by a UPS driver. it can be out of the office between two employees, but you, as the employer, have the responsibility to take action and address the situation. So with all of those fun facts in mind, that brings us to the end of our slide deck. John, do we have any questions?
We sure do. Let me just remind everybody that if you would like to ask a question, just locate the questions tab on your GoToWebinar display. You can type in your question and I will try to read that. We have a few here. The first one is in the public safety context, and it looks like someone in management. Can you institute an order that prohibits commanders not to quote unquote friend officers in an organization?
I asked for that question, didn't I? I did. Boy, I don't know. So this is the problem. With that. The problem with that is, as a public employer, you have to recognize your employees' rights to freedom of association. So freedom of association is protected under the First Amendment, along with freedom of speech, freedom of the press. So I suppose that the managerial employee could say, you can't tell me who I can be friends with or can't be friends with outside of the organization. So, I can't answer definitively, would a court find that to be infringing on that supervisory employee's First Amendment rights? I can't say that a court would definitively say it would, but I also can't say a court would definitively say it wouldn't. So it's probably not a good idea. You probably have more downside. I've had some success just trying to talk some sense into the supervisor employees to make them understand how much trouble they could get into if they engage in that behavior. And I've been fairly successful so far in convincing folks that they shouldn't be doing that, but I'm not sure you'd be able to pass a regulation that forbid that.
Great, thanks for that. Another question here is, what type of things should employers consider when creating social media policies?
John,
Rochelle,
that one. Yeah. So first and foremost, you want to make sure that your policy is clear and that your employees have a clear understanding of what constitutes the violation of that policy. You also want to delineate, for example, if you want to ensure that employees don't share confidential information via social media platforms, you want to also delineate what is confidential information. So there's no issues later on down the line when the employee says, well, I didn't know that that was confidential. And you also want to put forth a clear understanding of the investigation process that will proceed if there is any accusation regarding social media misuse. And you always want to have an investigation process in place. And then finally, of course, you'll want to have delineated what the penalties will be when misconduct occurs. So if it's going to be a gradual scale, your first offense, you get this discipline, your second offense, you get this, or whether first offense is a terminable offense, that needs to be spelled out in the policy so that the employees are aware of what they can and can't do and what the repercussions will be for violating or not acting in accordance with the policy. And then, of course, you want to make sure that you're applying the policy even-handedly, right? So that there's no accusation later on that, oh, it's only being enforced against, this group of people, but not that group of people. So those are some things you want to be thinking about when you're putting together your social media policy.
Great, thank you. Okay, next question is, in the New York dog walker versus bird watcher case that resulted in news and social media coverage that led to the dog walker losing her job, do you know the theory or standard the employer used in terminating that employee?
Well, so that employee New York is an at-will employment state. So as long as, let me speculate. My speculation is that that company had some sort of policy against racially offensive behavior. most companies do in their social media policies, but social media policies can be applied broadly to all communications, including in-person communications. So my guess is that that company had some sort of policy that forbid racially offensive behavior, and they used that policy to terminate her. If they didn't, you can still terminate people for any reason or no reason at all, so long as that person is not being terminated for their membership in a protected class or for engaging in protected conduct. So, unless she could demonstrate, the terminated employee could demonstrate, oh, they only fired me because I'm a woman. My coworker, Jack, over here said the same thing and he didn't get fired. She's not going to get anywhere with that. And frankly, her behavior was so offensive that if I was advising that company, I would tell them to fire her and take their chances because she's just going to make them look worse if they keep her on the payroll. So that's my guess. I don't know the answer, but that's my guess.
Okay, great. Here's a question, and just as a reminder, last call now for questions. A lot has been mentioned regarding Facebook and some MySpace references in the cases covered. Are there other social media sites that are getting employees in trouble these days, and should employers be paying attention to them?
Twitter is huge. I had somebody call about a Twitter case today. Twitter's huge. And I'll tell you why Twitter, in my opinion, is worse. Because Twitter communications are such snippets, it makes it so much easier for those snippets to be misinterpreted. So, and they can be rattled off very quickly in response to things. So we're finding people are just ripping off these Twitter responses or Twitter comments, and some of them sound terrible. You end up talking to the employee, and the employee says, "Oh my gosh, that's not how I meant it, but I see how somebody could think that's what I meant." And so yes, Twitter has been huge. Now, I had a call about a LinkedIn. If you're on LinkedIn, you can communicate. You can message people back and forth privately on LinkedIn. So I had a one LinkedIn case, but it's really a lot of Facebook, Twitter, commenting on other people's Facebook and Twitter feeds, that kind of thing. That's really what we're seeing.
And just to add to that, Christina.
Go ahead. Sorry.
Just to add to that, Christina, too, I've seen one instance with a TikTok video, and that was pretty new to me because I'm not very familiar with that social media platform. But we had an issue.
It's because your kids aren't old enough.
Yeah, I know. I feel like I'm behind the times. But we had an issue with an employee who posted something on TikTok that was very threatening to his coworkers and his manager, and then that was investigated. So there are a lot of platforms out there, in addition to the ones that Christina mentioned, that can really get employees into hot water.
Great. And the last question I have in the queue is for public employers. Are there any First Amendment concerns with respect to social media policies? I think you kind of hit on some of those.
Yeah, there are. I mean, you can't take action against employees because of protected speech. So let me tell you how these First Amendment public employee cases always come down. The first thing you have to figure out is what they've engaged in, is it protected speech? Let me tell you two different cases, and I'll make it brief. Vote for Donald Trump in the election, okay? That's expressing a political view, and it's probably protected speech. Donald Trump is a no-good SOB, and he should be shot. That's probably not protected political speech because it's actually a threat directed to a public official. It contains profanity. So public employees do have protections for their First Amendment speech, but the first question always is it protected or not? Because people forget not everything you say is protected speech. If you get mad at somebody and you say, "I'm going to kill you," That's not protected speech. That's a threat. That's probably a crime. So, if you're in a movie theater, a crowded movie theater, and as a joke you scream, "Fire, fire," and people run out and get hurt, that's not protected speech either. So the threshold issue that we always deal with is, yes, public employees have First Amendment protection, but was what they did or said actually protected under the First Amendment?
Great, thank you. Okay, so that about does it for us. We're going to wrap up now. As I like to do at all of our webinars, I just want to remind everybody that you'll get a really brief survey when you log out. We hope you just take a minute or two to complete that. We love to get your comments about topics you would like to have us cover, so please suggest those to us. I also like to mention that it takes us 24 to 48 hours, sometimes depending on the size of our attendance list, to issue our continuing education credits. So please bear with us as we get through that process. Those all will be emailed to you, and we typically email them to everybody, whether they need them or not. So if you don't need CE credits, you can just ignore that communication. The other thing I would like to do is a bit of a shameless plug. We always want you, if you can, to help us promote our events. There's, I'm sure, colleagues that you work with that weren't able to join us. Please share the link to this event page. It's going to have the recording up hopefully later today, and that'll be there 24/7 for their convenience. We also have, through the Labor and Employment Group, our Sophisticated Employer blog. We have a ton of information on that page, most recently a lot of the COVID-related items that you would expect to see. Check that out, and you can always add your email address and receive updates right in your inbox when new content is added. So at this point, on behalf of Rochelle and Christina, we want to thank you very much for attending today. We want to look forward to seeing you down the road, so please stay safe and have a wonderful rest of the afternoon.